everybody, it's me, Sylvia. I am here. We're going to do our watch party. It is official. The state is late. They have not submitted their paperwork. I have contacted the my people on higher up to find out if it's in the system. It's not in the system. They have not met the deadline. I don't care if they call the judge behind the scene. The records show that the state is late. Now, if the judge have do favoritism and they don't show up, we got some explaining to do, Judge Rachel. There's going to be some explaining to do, how the state can do whatever they want to do, be late, don't show up, don't do this, don't do that, and they still get it in. We're here documenting here that we have waited after this live started at 5:45, and there is nothing from the state. We've been on watch, looking at the motions. Steele filed a motion at 4:48. We have Steele's 3 motion, which, where's my Liz? Liz, are you here? Where's Liz? So she can read it. Liz, I want to send it to you. Where are you? Where's my Liz at? Liz, are you here? What happens now? I would say, listen to this. You guys asking, I don't know what happens with this, and I don't know. Maybe I can make a phone call and just ask one of the attorneys what happens when something like this happens. But to me, I know in the federal system, if you're late, they do not accept it. If you're late, they don't know that you're going to be late. They do not accept it. You might post it in there, but it is considered late, and then they do not accept it. They do not accept it, period. That's what I know with the feds. They can put it all in and all they want. If it's late, it's late, and they do not take it into consideration. They'll put it in the system the time they got it, when it was received, but they do not accept it. They'll mark it that it was late, and they're not accept it. So we will see. I think Judge Rachel will make her ruling without it. Oli, thanks for my AV. Oh, you did an AV membership? Where's AV? How's AV doing? Did she get herself moved in? Is everything going well with her, guys? All right. Steele filed 3 motions. The 3 motions that Steele filed was the amended, he's filed the amended list for the witness list. He filed the motion for a fair trial, as well as a motion for a list of dates and person who participated in the ex parte communication with the court, and the topic of same motion for mistrial based upon the judicial and prosecutional misconduct, and thus bar retrial. Okay. So, and then he filed, let's see, that's the other one. Hold on. The other one is Steele's motion for amended motion for correction ruling on improper objection by the state. Okay. All right, here we go. So that is what the motions that he has submitted in. Thank you, 444 for your super chat. Oli, man, you be doing it, Oli. Thank you. Oli just blessed somebody with 10 membership. Thank you so much, Oli. Oli, you be spoiling me, man, over here. You just spoil me. You spoil me. Oh, thank you, Oli. Thank you. So guys, hey Bumrich, how you doing? Let's see. Rich Bum, I'm sorry. Let's see. Where is my Liz? Liz, are you here so I can send you this motion so you can read it? So we're just documenting that the state is late, y'all. You guys are witnesses that the state is late. There's nothing has been submitted. I don't see no request for additional time. Nothing. I don't see any of that. So I'm not a lawyer or anything like that, but my thing is, Miss Sylvia said, okay, there you go. There you go. There you go. Hold on. I got to send it to Liz, y'all. Hold on. One second, Liz. There we go. All right, here we go. And then let me copy the stream so I can send that to you too. Hold on, y'all. Just trying to get Liz hot stuff right here. Liz, the link is going to be in the email. I just sent it to you. I just sent you everything. Okay, I still have somebody checking, so if it pops in, they will let us know. I have my folks checking the site to see if anything comes in. Okay, so okay. Let me ask Mr. Weinstein what happens when they do not meet the deadline. One second, y'all. Hold on a second. Let me just ask Mr. Weinstein. Oh, let me ask this person what happens when they miss the deadline. I really want to know what happens in Fulton County when they miss the deadline. Hey, Liz.
Hey, can y'all hear me?
Yeah, we can hear you. So you want me to put it up first?
Yeah, I got it on my phone so I can read it, but you could just put it up for them to follow, right?
Which one are you reading first?
Looks
A
like the
minute.
motion for the fair trial.
Fair trial. Okay, let me go get that one.
Make sure I'm loud. Hopefully, they'll
All
say.
right.
Ready?
All right, guys. Liz is about to read the motion for a fair trial, guys. Just one second. Let me just go ahead and present this. Guys, this is a watch party, and while we're waiting, while we're watching, we're going to be reading the motion. Steele has submitted 3 motions while we waited for the state to do their one. So, all right, here we go. How do we buy membership? Somebody put in the link, please. Okay. And I do have a treat for you guys in a few minutes. So, Just bear with us a second. Let me just go ahead on and do this while we do our watch party.
Yeah, and I'll just pause if I'm in the middle of reading.
All right, go ahead.
All right, motion for a fair trial as well as motion for a list of dates, persons who participated in any ex parte communications with the court and the topic of same. Motion for mistrial based upon judicial and prosecutorial misconduct and thus bar retrial. Comes now Mr. Jeffrey Williams by and through undersigned counsel and hereby files this motion for a fair trial, as well as motion for a list of dates, persons who participated in any ex parte communications with the court and the topic of same. Motion for mistrial based upon judicial and prosecutorial misconduct and thus bar retrial in the above referenced case. In support of this motion, Mr. Williams shows as follows. Number one, Mr. Williams is innocent of all crimes in the above referenced indictment. Number two, from the inception, this trial has been constitutionally unfair as this court has failed to be impartial to Mr. Williams and or his counsel and has been objectively biased in favor of the prosecution. Some examples same include but are not limited to the below. One. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27th, so that objections could be made prior to presentation of the opening statement. Well, these are footnotes, right? On Friday, November 24th, this is number two, Lawyer Love shared her purported demonstrative aid via email. During opening statements, however, Lawyer Love showed a completely different, never-before-seen demonstrative aid, which was in clear violation of the court's order. The court denied Mr. Williams' timely motion for mistrial, and there were no consequences meted out by the court for Lawyer Love's intentional misconduct. During the same opening statement, Lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in this case. Specifically, during her PowerPoint presentation, Lawyer Love highlighted to the jury that undersigned counsel represented co-indictee Blaylock. Again, there were no consequences meted out by the court. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27th, so that objections could be made prior to the presentation of the opening statement. On Friday, November 24th at 4:58 p.m., Lawyer Love shared her purported demonstrative aid via email. During opening statements, however, Lawyer Love showed a completely different, never-before-seen demonstrative aid, which was in clear violation of the court's order. The court denied Mr. Williams' timely motion for mistrial, and there were no consequences meted out by the court for Lawyer Love's intentional misconduct. During the same opening statement, Lawyer Love defied another court order by introducing to the jury that undersigned counsel had represented other people charged in this case. Specifically, during her PowerPoint presentation, is this like a repeat or? Specifically, during her PowerPoint presentation, Lawyer Love highlighted to the jury that undersigned counsel represented co-indictee Blaylock. Again, there were no consequences meted out by the court. Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury that witness Mr. Adrian Bean was taken to Grady Hospital by police directly from the scene of his arrest on September 11, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence as Mr. Bean never went to Grady on September 11, 2013. Lawyer Love's allegations against undersigned counsel were proven beyond any doubt to be totally knowingly false. Yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. Over Mr. Williams' objection, when the state was attempting to introduce the January 26th...
Hold on, y'all. Hold on. It's in. It's in.
Whoop.
Hold on.
Let me mute so I can party.
Okay, you want to continue reading it, and I'll upload it. I'll send it to you, and we can continue after this. Liz?
Yeah, you want me to continue this first? Okay.
Yes, yes.
All right. So Lawyer Love's allegations against undersigned counsel were proven beyond any doubt to be totally knowingly false. Yet the court did not admonish Lawyer Love at all for falsely accusing another member of the bar of being untruthful. Hold on, I'm trying to find myself on my phone because it's easier to read. I'm going to be sick. All right. Okay. Over Mr. Williams' objection when the state was attempting to introduce the January 26, 2015 social media posting from co-indictee Garlington's account during testimony of Detective Gaither, Lawyer Love told the court that only Mr. Williams' voice could be heard on this video audio, except for one other voice saying words like "yeah" in the background. Undersigned counsel told the court that Lawyer Love was incorrect and that several persons' voices were audible on this social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. Of course, Lawyer Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. Although it was objectively proven that Lawyer Love falsely accused another member of the bar of misconduct, lying to the court did nothing to admonish Lawyer Love. This pattern of permitting prosecutorial misconduct illustrates that the court wrongly favors Love and the state of Georgia in this case. On Thursday, June 6, 2024, as well as Friday, June 7th, Lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail recordings of Mr. Copeland. This was another knowing, malicious, false allegation by Lawyer Love. The court remained muted and failed to admonish Lawyer Love. On Friday, June 7th, Lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duty to his client. The court remained silent while Lawyer Love hurled more false allegations. In the jury's presence on separate occasions, the court wrongly accused undersigned counsel of being unprofessional as well as unprepared. Both allegations are completely false, yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, and as undersigned counsel was neither unprofessional nor unprepared. The court's overly prejudicial and
Okay, Liz, I'm sorry. Go ahead, and I just send it to you. Sorry, guys, I have to stop this. We got to read the state because it's 80-something pages. So.
Oh, we better get where's Randa Baby? Is she in here too?
I just sent it to her too. Just check your email.
All right.
There it is right here. You got it? Okay. All right, y'all.
Start?
Yeah, go ahead and start. Okay. All right, guys, there we go. Where Randa is, she said she was
good. That's okay. I mean, I'll just keep going until she gets here, but it's 81. Are we reading them all?
We're going to read it the whole 81 pages.
Let's go, y'all. State's response to defendant's motions to recuse Chief Judge Ural Glanville in the trial of the above-styled case. Introduction. Midway through this now months-long trial, defendant Jeffrey Williams and defendant Diamante Kendrick have each filed a motion to recuse Judge Glanville, hereinafter motions, and defendant has filed a supplement to the motions, hereinafter supplement. The state recognizes that Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to this honorable court, but the state respectfully submits that at the time of reassignment, Judge Glanville did not make the three requisite determinations. Number one, whether the motion was timely filed. Number two, whether any affidavit made in support of the motion is legally sufficient. And number three, whether if some or all the facts set forth in the affidavit are true, recusal is authorized. Accordingly, it falls to this honorable court to make those determinations. As set forth below, though defendant's motion and supplement are in part timely, and the affidavits in support of defendant's motion and supplement are in part legally sufficient, none of the facts set forth in defendant's affidavits, even if assumed to be true, would authorize recusal. Defendant's motion and supplement should therefore both be denied. Number 2, factual background. A, the calling of state's witness Kenneth Copeland on June 7th. On June 6th, in response to an inquiry from counsel for the defendants in this case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7th. After the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland and that Mr. Copeland would be asserting his Fifth Amendment privilege if called to testify on June 7th. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stilwell, who are represented respectively by Brian Steele and Max Shart, Melnick copied Brian Steele and Max Shart on his communication with the state regarding Mr. Copeland's intention not to testify. Set forth in the affidavit are true, recusal would be authorized. If all three of these conditions are met, the trial court must refer the motion to another judge to hear the motion to recuse. If any one of the conditions is not met, the trial court does not err in denying the motion. Okay. Since trial judge had not made the three requisite determinations at the time the motion was reassigned, the timeliness of the motion, the legal sufficiency of the affidavit, and whether assuming any of the alleged facts were true, recusal would be warranted. And since he could not make such determinations after the motion had been referred to another judge, it was necessary and proper for the assignee judge to have made these determinations, which the alleged recusant judge was supposed to have made. In preparation for trial, Deputy District Attorney Hilton, along with her investigator, had met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state an intention to plead the Fifth or say that he was represented by Melnick. Nevertheless, after receiving Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June 7th. Pursuant to OCGA 24-5-507, after receiving Mr. Melnick's email, the state presented to Chief Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court after being granted immunity. The court issued an order granting the state's motion. On June 7, 2024, after court was called to order, Melnick appeared before the court and informed the court that Kenneth Copeland, I'm going to call him Woody because it's easier, Woody would be asserting a Fifth Amendment privilege against self-incrimination. In presence of each defendant currently on trial and each of their respective attorneys, Judge Glanville called Woody to the stand and explained to Woody that the state had sought and been granted an order of the court pursuant to OCGA 24-5-507, directing Woody to testify and extending immunity for Woody's compelled testimony. Chief Judge Glanville further explained to Woody in the presence of every defendant currently on trial and each of their respective attorneys that should Woody refuse to testify, he would be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Woody thereafter stated his intention to testify, and Melnick looked toward Mr. Steele and Mr. Shart and shrugged his shoulders. After motions hearings, the court recessed for lunch. During the lunch hour,
That's a lie. That's a lie.
Oh, tell us the tea.
That's a lie. He did not shrug his shoulder, guys. We got the record. We got the view of what happened. Remember, we got the footage. We have the footage. We can give the footage to Mr. Steele. Come on, we have the footage. He did not shrug his shoulders to them.
Chat, call Mr. Steele. Tell him we need to give him some information.
Oh my God.
During the lunch hour, Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. After lunch, the jury was called in and Woody took the stand. Woody cheekily answered a few questions, and when asked his age and years, Woody responded, "I plead the Fifth." The court allowed no further questioning by the state and immediately excused the jury, held Woody in contempt, and ordered Woody into custody. In open court, in the presence of all the defendants currently on trial, and in the presence of each defendant's respective attorney, Judge Glanville informed Woody and Melnick that he would bring Woody back into court on Monday, June 10th, to allow Woody to purge himself of contempt by testifying. Melnick announced that he was going on vacation, would in no way be present on Monday, and would appoint stand-in counsel Kayla Bumpus to represent Woody in court the following Monday. The June 10th meeting regarding contempt proceedings initiated against Woody upon motion of the state, attended by counsel for Woody, attorneys for the state, Woody, and the Honorable Chief Judge Glanville. On Monday morning, prior to the start of the court, the state requested from the court an in-chambers meeting with counsel for Woody, the court, and an attorney for the state to discuss the contempt proceedings initiated against Woody upon the state's motion. The court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. That's also a lie, isn't it? Made a record of the entire meeting. Present during the meeting were CDDA Love, attorney Kayla Bumpus, investigators for the state and Judge Glanville, and later Woody and Hilton. Matters addressed during the meeting concerned only the contempt proceedings against Woody, and the topics addressed included Woody's rights and representation as it related to the proceedings, Woody's obligations under OCGA 24.507, and answers to questions posed by Woody regarding matters related to OCGA 24.507, such as the distinction between purging oneself of contempt as addressed by OCGA 24.507 and perjury as prohibited by OCGA 24.507. With the exception of the times where Woody was afforded an opportunity to speak with Ms. Bumpus alone, the entire meeting was taken down by the court reporter. Brian Steele's defiance of the court's commands and subsequent contempt ruling. After the meeting regarding Woody's contempt and obligations under OCGA 24-5-507, Brian Steele stood in open court and demanded a mistrial as he loudly and repeatedly hurled at the Chief Judge Glanville accusations of misconduct. Most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed Glanville's commands to reveal the Mr. Steele's source of information regarding in-chamber matters. After Mr. Steele refused to comply with the court's instruction, the court held Mr. Steele in contempt of court. After defiantly and repeatedly disobeying the court and being held in contempt, Brian Steele filed the motion and supplement. Number 3, argument and citation of authority. No fact set forth in defendant's motion or supplement authorizes recusal of the judge, Glanville. To warrant disqualification of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from an extrajudicial source and result in an opinion on the merits on some basis other than what the judge learned from his participation in the case. There is a presumption that a trial judge acting as a public official faithfully and lawfully performs the duties devolving upon him. Number 12, determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal, present questions of law. 13, here with the exception of the defendant Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the court for not being prepared. Defendant's motions and the supplement are based entirely on the defendant's assertions regarding the June 10th meeting. Regarding the contempt proceedings against Woody and actions taken by Chief Judge Glanville after Mr. Steele defiantly refused to comply with the court's repeated request to provide the court with information. Georgia Code of Conduct 2.9, regarding ex parte communications, provides that judges shall accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to law. No defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Woody or any subsequent contempt proceedings initiated on the motion of the state involving Woody's refusal to testify. Number 14, since no defendant in this case had a right to be present at the June 10th in chambers meeting with Woody and his counsel regarding the contempt proceedings against Woody, the fact of the meeting provides no grounds for recusal. Respectfully submitted this 10th day of July, signed Adrian Love. So now are we going to go to Exhibit A, Melnick, or do we already read this? That's what I have.
Wait a minute. All this stuff is just redundant.
Oh, look. No, This next, wait, so this is the fuck you email, but it doesn't say fuck you. Remember? Oh, I'm sorry, I'm cursing. My bad.
You know what, Liz?
No, but I'm just reading.
Liz?
Chat, I'm just reading what's here. Exhibit
Liz?
A, though, we didn't have that.
That didn't say no F you, did it? So you just decided to say that word.
That's what they said he said, though.
Yeah, but you said
They
you
lied.
didn't read that.
Nope.
Go ahead. Go ahead. Read that. Read that.
All right. So this is Melnick's email. So on Friday, Love had wrote just down at the bottom, is your concern for your client off of Mr. Steele's and Mr. Shards? His response is, my concern is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. You have put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client. And that's what he said on Bumpus's Live. They didn't say F, the letters F and U. He said this last line, if you think I'm doing anything besides protecting my client. So now moving down.
This is all old
Yeah,
stuff.
this is all.
Yeah, a lot of that is exhibits. That's what I was trying to tell you. It's not nothing. It's just exhibits. And then the last part is a transcript.
Yes, it's
With,
all.
yeah, the ex parte transcript.
I mean, so you waited
Hey.
all this time of being late and because
Girl,
I've
everything.
been sitting here this whole time. I've been sitting here this whole time. She was reading. I wasn't gonna cut her off.
No, not you. I'm talking about Love.
Just to submit those few pages, y'all.
She just.
yeah, I mean, this is. But the only thing we didn't see the last time was the real response from Melnick. That's in here now, but it wasn't in the last when we read them yesterday.
Yeah, this is all stuff that we have read. All this time for this.
They were late putting this in just for all this.
Just
Like
right,
all of
like
this is old.
This is old, y'all.
Well, Marley, if she's in the chat, I can't see it, but she's about to have a fit. We waited all this time for this.
This is late. It was late. It was late. It was late, John. And just how many pages did you actually read?
Honestly, I don't even know because I don't have a page there.
Let me go back up. Hold on a second. I don't think she read 7 pages, y'all.
It was 9 pages.
It was 9 pages for real.
Yeah, it was 9 pages.
But it didn't say much. There was mostly footnotes. I was getting confused if I was even supposed to read the footnotes. So
Randa, it wasn't full 9 pages, ma'am.
That goes into the 9th page. What are you talking about?
Not fully 9 pages because it's footnotes.
You said fully. Oh, it's still 9 pages, bro.
I really read the footnotes too, but it didn't say much of anything in those pages.
All I'm saying is we waited and she was late for a few pages. You could do a 9-page page for less than. You don't need 48 hours to do this. You could do that in 1 hour.
The law students could have done this part. What are they?
Right. She said 80-some pages. I'm thinking, oh man, it's about to be a lot of stuff to read. And that's answering all 3 motions.
Randy, why are your phone so loud?
For me?
Probably because I got my volume up because I couldn't hear. Hold on. Oh, and I got my Bluetooth in my ear.
Yeah, you loud. Okay, say it again. Say something.
I got my Bluetooth in my ear. It's probably gonna be loud because I got my Bluetooth and I'm not taking my Bluetooth out.
What's the chat saying? I can't even see.
Okay, so I guess we're gonna go back to Steele. Could you help her with the Steele reading then? Because we got more stuff from Steele reading than this mess. It's not a real response, y'all. I'm sorry. It's not a response. What did she say that helped, y'all? Randa.
What'd you say, girl?
I said, what did she say that helped? strengthen his.
I don't know because it sounded to me as though she altered what her view was of what went down, and basically just put everything that they've been putting in motions, except putting it to her liking.
But absolutely nothing. She hadn't said anything that's going to help.
She has, in my opinion, it's nothing in this that is like wow, like she did her thing in this. Like it's nothing in it, nothing in it.
Brenda said, I've been at work all day. Okay. And somebody she wants to help.
That's why I say again, why did they even need an extension? It literally was what 9 pages, if that. So you got 9 pages with a whole bunch of footnotes, and you were told to do this last week,
They tricked us.
right?
Yeah, but she
Last
didn't.
week,
The time she took to do those 2 pages asking for more time, she could have just added the extra 7 pages. I mean, come on, y'all. These are supposed to be attorneys who went through law school, who did papers, had deadlines. So how do you not? I don't get it.
I know I said last night, though, that they were up to something, too. We were just talking about this last night.
Pedro said Love had an emergency.
Now, there's more to it than that, though. There's more to it than that. Why they asked for the extension only to give us this? This is not even saying nothing.
nine pages.
Everybody's so. Kim said she's so mad.
Everybody waited for that, Sylvia. 9 pages. Oh, you gotta
We
love it.
hyped it up. We had a watch party and everything ready for this.
Y'all did.
Well, anyway, Weinstein refiled the emergency Mandamus. So let's go ahead and finish reading Steele's thing.
Well, I'm gonna drop down because I'm at the nail shop.
Okay, hon.
All right, I have the document. I'll just keep going. Can you hear me?
Yeah, the not fair one, right?
What?
Not fair. And now you too low. She was loud and you too low.
All right. Can you hear me better?
Yeah, I can hear you better now.
I got to sit really on top of my iPad for this, so hold on. I'm going back to the one that I was reading before. So this was Steele's motion for fair trial, okay?
Start where we were. Oh, we were at page 3. Well, page 4, misrepresentation.
I'm at the court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel.
What page are you on? What page are you on?
I don't know because my pages aren't numbered.
Okay. What's the top of that page? What does it say?
I'm on VII in the jury's presence. It's letter. It's
VII. Okay. All right, I got you. There I go.
Okay. In the jury's presence on separate occasions, the court wrongly accused undersigned counsel of being unprofessional as well as unprepared. Both allegations are completely false. Yet the court's bias is so deep that the court refused to instruct the jury that the court's declaration was completely wrong on both occasions, as undersigned counsel was neither unprofessional nor unprepared. The court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel and its refusal to instruct the jury to disregard these impermissible and false allegations, as well as the court's failure to apologize for its baseless claims, proves bias, for the state and prejudice against Mr. Williams and or his counsel. These above few examples raise reasonable questions concerning the court's partiality and bias against Mr. Williams and his counsel's efforts to obtain a fair trial and a fair tribunal without prosecutorial misconduct. Number 3, this court's impartiality is objectively questioned and the court must be recused. See, for example, Johnson v. State. This court has falsely and wrongly accused undersigned counsel of being unprofessional and unprepared in front of the jury. Neither claim has any modicum of truth. The prosecutor sat silent as the court wrongly and falsely accused undersigned counsel of improper conduct in front of the jury, all prejudicing Mr. Williams. The court has violated its duty of neutrality, impartiality that it was sworn to undertake. Even knowing that the court has falsely accused undersigned counsel of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper, highly prejudicial comments. This conduct shows that the court is biased against Mr. Williams and or his counsel and favors the state, as no unbiased judge would not correct such a serious misstatement made in front of the court. The bias of the court is objectively proven. To date, the court has done absolutely nothing to stop Lawyer Love from continued misrepresentations, abuse of others, and false allegations. Instead, on occasion, the court speaks in generalities and reminds both sides to be professional. This is not a both sides issue. This is a one-sided issue resulting in prejudice to Mr. Williams and a violation of his constitutional right to a fair trial. Number 5. Mr. Williams languishes in jail without bond since arrest on May 9, 2022. Mr. Williams has been and is being denied his constitutional right to due process, a fair tribunal, and a fair trial based upon prosecutorial misconduct and judicial misconduct. The court has exhibited a pattern of bias in favor of the state and against Mr. Williams and or his counsel, and the court has failed to admonish Lawyer Love to prevent her past and continuous misconduct. This failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. Number 6. The court has effectively joined the prosecution team by permitting Lawyer Love to defy court orders without consequence. The court has imposed absolutely no sanctions to stop or deter this prosecutorial misconduct. As a result, Mr. Williams has not received a constitutionally mandated fair trial, does not have a fair tribunal, and his due process rights have been repeatedly violated because of the prosecutorial and judicial misconduct. Because the state has blatantly violated Mr. Williams' rights, they have goaded Mr. Williams into making motions for mistrial, all of which have been denied. The above few examples are egregious and cast a dark, ugly stain onto Georgia's justice system. The below further captures the violation of laws that lawyers Love and Hilton and the court display herein. Number 7. On Monday, June 10th, the court, along with lawyers Love and Hilton, engaged in an ex parte meeting with, among other people, previously sworn witness Woody, for whom an order of use immunity had been issued on Friday, June 7th. No notice of this ex parte meeting was provided to any attorney for any of the accused on trial. In fact, the accused and their counsel were wholly unaware that this Star Chamber meeting was occurring or had occurred until well after the fact. Woody had previously been called to testify on Friday, June 7th. He asserted his Fifth Amendment rights in front of the jury and was held in contempt and incarcerated until such time as he agreed to testify, pursuant to the order granting use immunity. Once undersigned counsel confronted the court with a motion as to why the court held this impermissible ex parte meeting on Monday, June 10th, the court and the prosecutors eventually admitted in open court that this ex parte meeting had in fact occurred on the morning of June 10th. This admission occurred only after undersigned counsel revealed, based upon information and belief, there's that phrase again, that this impermissible illegal meeting occurred. Undersigned counsel proffered that statements were made to and in Woody's presence by the court and or lawyers Love and Hilton, all acting in concert. asserting that Attorney Melnick failed to represent Woody's interests and explaining the amount of time that Woody would be held in custody unless he testified as urged by lawyers Love and Hilton in the court. On June 10th, the court denied undersigned counsel's request for the transcript of the improper, unconstitutional ex parte meeting and denied undersigned counsel's timely motion for mistrial based upon, including but not limited to, Mr. Williams' federal and Georgia constitutional and statutory rights. That included the right to due process, a fair trial, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings. Instead, the court held undersigned counsel in contempt and ordered undersigned counsel to spend 20 days in jail, despite the assertion of valid privileges in declining to answer the court's demand to reveal the supposed source of the information about the ex parte meeting. In the afternoon of Monday, June 10th, lawyers Love and Hilton sat mute and permitted this travesty of justice to continue. Later, lawyer Love argued that the ex parte conversation with sworn witness Mr. Copeland, Woody, was ethical, just, and proper, despite it violating multiple constitutional provisions, judicial canons, and rules of professional responsibility. 8. Furthermore, Mr. Williams requests a list of people involved, the topic of the same, and a transcript of all of the ex parte meetings, if any, conducted by the court, involving anything to do with this case trial. Additionally, Mr. Williams also moves that any document that is filed under seal be reviewed by a neutral judicial officer to determine whether the same needs to be unsealed and shared with Mr. Williams under the statute and or constitutional provision. Wherefore, undersigned counsel respectfully requests that one, lawyer Love be barred from uttering false allegations or disparaging words toward another. Number 2, lawyer Love conduct herself with professionalism and in full compliance with the Georgia rules of professional responsibility, which govern the conduct of lawyers in the state of Georgia if able. And 3, a mistrial be declared based upon lawyer Love, lawyer Hilton, and the court's failure to protect the above stated constitutional rights, as well as Mr. Williams' right to be present under Article 1, Section 1, Paragraph 12. Maybe that's not 12. Paragraph XX, X11 of the Georgia
That's
Constitution.
12. That's 12.
It was 12?
Mm-hmm.
Yeah. The right to confront witnesses, right to a fair tribunal, right to a fair trial, right to due process, right to present a defense and call witnesses. This 10th day of July, respectfully signed by Brian Steele and Keith Adams.
All right. The next thing we're going to have is the amended correction ruling by Steele.
All right, hold on. I have to see what I have now. Amended correction. Okay. Amended motion for correction ruling on improper objection by the state. Comes now Mr. Jeffrey Williams, by and through, undersigned counsel, and hereby files this motion for correct ruling on improper objection by the state in the above referenced case. In support of this motion, Mr. Williams shows as follows. Number 1, Mr. Williams is innocent of all crimes in the above referenced indictment. Number 2, the prosecution has made objections on countless occasions based upon OCGA 248801, self-serving statement of a party. This honorable court has, in almost all instances, sustained the objection. This objection and ruling are not well-founded. In Walker v. State, the Honorable Supreme Court of Georgia wrote that the blanket policy against self-serving statements might not have survived the passage of Georgia's new evidence code, our high court in Walker v. State. This Super went on to note that the proposed new rules would not retain a self-serving statement rule, and thus if the hearsay statement of a party is admissible under hearsay exception, the fact that it is self-serving should go to weight, not admissibility. Number 4, Mr. Williams has offered into evidence on many occasions supposed utterances of Mr. Williams, not self-serving statements, but in oftentimes lyrics, that the court has denied admission into evidence based on the prosecution's potentially specious objection to self-serving statements. All of these issues are preserved for appeal in the ordinary course of litigation. Going forward, Mr. Williams asks the court to reconsider its understanding of a potential objection of self-serving statements based upon Walker v. State, Supra, and the warning and notation by the Honorable Supreme Court of Georgia. Number 5. Moreover, Mr. Williams' lyrics of social media postings should not be barred by any hearsay objection because they become relevant based upon the prosecution's presentation of evidence under the rule of completeness, and oftentimes are not admitted for the truth of the matter asserted, but for the effect on the listener. Sounds a lot like Hilton's words. Or to put conversations issues into context. However, this court, for the most part, has prevented Mr. Williams from receiving a fair trial by this court sustaining possible meritless objections by the prosecution. Number 6, if this case were tried prior to January 1st, 2013, then under the former evidence code, self-serving statements were generally inadmissible hearsay where a criminally accused chose not to testify at trial and subject himself to cross-examination. We are well past January 1st, 2013, and the former evidence code no longer has any applicability. Number 7, moreover, self-serving statements go to a statement of innocence made concerning allegations at trial, not prior lyrics, social media postings, such as the state has been objecting to, and this court has been sustaining them more probable than not. Wait, mine's cut off. More probable than not specious objections. A case decided before January 1st, 2013, new evidence code took effect, but commenting that the State Bar of Georgia's comment on OCGA states that the new evidence code would not retain the self-serving statement rule, and that under OCGA 24402, all relevant evidence shall be admissible except as limited by constitutional requirements or as otherwise prescribed by law and other rules pursuant to constitutional and statutory authority. Number 8, it is interesting to note that there is no hearsay provision in our new evidence code that even uses the term self-serving statement. See entire OCGA. Number 9, courts from across our country who use federal rules of evidence have all come to the conclusion, as opposed to the state's continuous self-serving objections, and this court sustaining same, a flat rule against self-serving statements makes no sense. See, for example, from almost 40 years ago, United States v. Jackson. The prosecution should not be allowed to continue to stop Mr. Williams from presenting the truth in this case through competent admissible means based upon specious objections. Number 10. Furthermore, while discussing I don't know this word. Am I saying it wrong? Specious prosecution objections. These objections too vague when there is nothing vague about the question posed on cross-examination. The objection to facts not in evidence need not be sustained any further. It is abusive to the Sixth Amendment to sustain these objections, as lawyers for the criminally accused have the right to not only cross-examine, but to cross-examine effectively, thoroughly, and siftingly, and ask the leading question when Mine's cut off. Where am I? Oh, which introduces facts is not objectionable. The questions are not evidence, therefore the question does not interject facts not in evidence, but the question combined with the answer becomes evidence. Thus far, on a multitude of countless occasions, cross-examiners have been totally barred from presenting competent, truthful evidence from the jury based upon this wall of specious objections that are being sustained. This must end as well. The constitutional right to effective assistance of counsel, the constitutional right to confront and cross-examine witnesses, and the constitutional right to a fair trial have all been infringed upon to date in this trial. The past cannot change, but the future can be corrected. Number 11. The state argues that if a party is silent, that they then adopt a statement by someone else. Same is not true. COCGA 801. Same is not true because there must be a manifest adoption or belief that it is true. Wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this court to grant the above requested relief and going forward consider whether self-serving statements is even a valid objection under Georgia's current law. This 10th day of July, respectfully submitted by Brian Stale and Keith Adams.
All right, guys. Okay, now we have the updated list, updated witness list from Mr. Steele.
All right, I'm going to drop down now, right?
All right, thank you so much.
Of course.
Appreciate you. All right, guys, here's the updated witness list here. Okay, here we go. The updated witness list for Mr. Steele. Okay, you ready? And you have, I just want to show you the names that we have. Judge Glanville right here. Hilton, Attorney Hilton. And Love right here. Y'all got it? And let's see, I think it was, let me see, Brown is in here. Hold on a second. Let's see. I thought, did I see Brown in here? I need to go back up. Let's see if we see Brown. I was looking for the other attorney, the other people that was in there. Brown. I don't see Brown. I don't see Hamilton either. I don't see them. The other ones. Yeah, I don't see the other ones. I just see Hilton. I see Glanville, and I see Jimmy Kennedy. I don't know who Jimmy Kennedy is. I don't see Brown. Yeah, T.I. is going to be there. All right, guys, that's it. I just wanted to bring you guys this stuff here. And I'll see you guys later. Bye.